Friends, I welcome you all at Swayam platform. Today we are going to start the last week of the discussion where we focus on the law of maintenance and adoption. But before starting the today's lecture, I want to summarize what we discussed in a previous week. Friends, in the last week, we discussed about the Hindu law of succession where we discussed the Hindu female dying intestate, what kind of rule laid down by Hindu Succession Act, especially in the reference of section 14 and section 15 and 16. Friends, we also discussed the general rule in a case of child in womb, in a case of simultaneous death. We also discussed the per stirpes and per capita succession. And we also discussed the disqualification of heirs, and a very important topic is right to preemption under section 22 of the Hindu Succession Act. And therefore, by the discussion in the previous class, we try to understand and correlate the entire concept related with the succession of a Hindu dying intestate. Now friends, I want to enter into this week. In the present week, we will discuss about the adoption and the maintenance. And two different subjects now governed by the Hindu Adoption and Maintenance Act 1956, which generally known as HAMA Act, which passed in the year 1956. Friends, before starting the discussion, I want to discuss with you the learning objective of the today's lecture. Friends, the learner will able to understand the meaning of adoption, law of adoption under the Shastric Hindu law, fundamental changes in law of adoption under the Hindu Adoption and Maintenance Act 1956, and introduction of Hindu Adoption and Maintenance Act 1956, the scope of Hindu Adoption and Maintenance Act, and the application of Hindu Adoption and Maintenance Act. Friends, these are the learning objectives. We will try to understand the Shastric Hindu law, where adoption accepted, and now the law of adoption substantially changed by Hindu Adoption and Maintenance Act. So we will discuss the concept, definition of adoption in one hand. On the another hand, we try to correlate the concept with Shastric Hindu law, and then we discussed about the, then I will discuss about the Hindu Adoption and Maintenance Act, friends. Friends, before starting anything, I want to discuss with you about the meaning and definition of the adoption, friends. Friends, adoption is a formal legal process of establishing a permanent parent-child relationship between individuals who are not biologically related for the rest of their lives. Adoption means the process through which the adopted child is permanently separated from his biological parents and become the lawful child of the adoptive parent with all the rights, privileges and responsibility that are attached to a biological child. Friends, this is the fundamental feature of the adoption. Friends, for the purpose of the adoption, we can recognize two different kind of family: natural family and adopted family. Natural family means family of the birth of the child. After the adoption, a person loses an entire relationship from the biological family and restore everything in the adopted family. This is the idea of adoption with certain conditions and exception. In this case, a child may have biological parents and adopted parent, and after the adoption, there is no role of biological parents in the life of the child, and child for all the context will be attached with the parents who adopted the childs. Friends, Mullah also defined the idea of adoption. According to Mullah, adoption is the admission of a stranger by birth to a privileges of a child by a legally recognized form of affiliation. The adopted child is then taken as being born in new family, and he acquires rights, duty and status in the new family, and his ties with the old family become cut off. So as we discussed that after the adoption, child cut off all the relations, rights in the biological family and associated with the family who adopted the child. This is the fundamental notion of the adoption. Friends, if we want to talk about the concept of adoption in Bharati tradition, the concept of adoption well recognized in Bharati tradition under the Sastric Hindu law. Sastric Hindu law attached more importance and significance in favor of son, and therefore in the absence of son, a person is authorized to take a person in adoption. This is the position of Sastric Hindu law. Now the fundamental question is, why Sastric Hindu law provides greater importance to a son? As per Hindu view of life, Hindu law attached more importance to a son because Hindu philosopher propounded that man is born with three depths. The first is depth of rishis, depth of God, which known as Devarin, and the third is depth of ancestor, Pitrarin. Means Rishirin, Devarin and Pitrarin. Three different kind of depth considered to be possessed by a man. And a man repay the debt to Rishi by the study of Veda, Brahmacharena. The debt of gods by offering sacrifice, Yajnena. The debt of ancestor by giving birth of a male child, Prajaya. Friends, we already discussed that the objective of marriage under the Hindu law recognized as Dharma Prajaratyartho hi Vivaha. Dharma Prajaratyartho, Rati. Recognized three different kind of objective of marriage. The man possesses three different kind of rin, popularly known as Rishi rin, Dev rin and Pitra rin. And a person may discharge these debt by study of Veda, by offering sacrifice in the form of Yajna, and by giving a birth of a male child like Praja. So therefore, a person cannot be considered debtless if he not procreate a child, especially a male child, as per Hindu view of life. And friends, it is stated in the Taittiriya Samhita, Yajmano vai brahman sthiram ridavan jayate brahmacharnena risibhya yajnena devebhya prajapritibhya eva va agraniyah putri jatva brahmachari vasi. As per the Taittiriya Samhita, these three kind of rin may be discharged through the brahmacharnena yajnena prajaya. Friends, the Vasishtha also said that when the father see the face of his living son on his birth, his debt is transferred to that son and he attain immortality, and thus says the revelation that are immemorable heaven for a man who has a son, but there is no place in heaven for a sonless man. The Vasishtha stated this. Ridam asmin satrayati amrit tattvam gacchati pita putrascha jayatasya pascheta jivato mukham anantyam putranam loka na putraste loke astim sruyate. The same is also discussed by the Manu, and Manu discussed that the son, according to the Hindu view of life, is known as Putra because he saved his ancestor from a hell as Put. The son confers benefit upon the soul of a dead ancestor by offering pinda and water to them on the occasion of Sadra. Punnama namo narakad yasmad trayet pitaram shrutam tasmat putra iti proktah swayameva swayam bhuva. Son is considered as Putra. Why he recognized as a Putra? Because son is responsible to Taret iti Putraha from Punnam. Under the Sastric Hindu law, the law of adoption is given in the Smriti, but no leading Smriti contains law on adoption in detail. The other sources are Daibhag and the Mitakshara. Apart from these, there are two famous essays on the subject of Dattak Mimamsa and Dattak Chandrika. Dattak Mimamsa is written by Nanda Pandit and Dattak Chandrika by Devan Bhatt. The judicial committee recognized it an authentic treatise. Beside this written law, there is also the custom and the customary law on the subject of adoption. Notable among them are the custom in the Punjab and the Jain. During the British period, not a single piece of legislation was enacted concerning adoption. However, the British legislature has a valid ground to at least pass a law abolishing the doctrine of relation back. Friends, how we can analyze the Sastric Hindu law? Sastric Hindu law put extra emphasis on son. Therefore, in absence of biological son, a person is authorized to adopt a child. Friends, under the Hindu law, scholars recognized different kind of son. Dattak Putra, Aurash Putra, Jaraj Putra, Kaneen Putra. Different kind of son is recognized because son is considered an important element for the purpose of salvation of a man. And with the help of a man may discharge the debt in the world and beyond this world. For example, we also discuss a concept of pious obligation of son, पुत्र के पुनीत कर्तव्य का सिद्धांत, where we discussed about that son is under the obligations to repay the debt of father, grandfather, great grandfather, and the provision of pious obligation is not in the favor of creditor but in the favor of the ancestor of the child. The entire Hindu system is based on the assumption about a son. Therefore, the last ceremony of man, cremation, to be discharged by the son, and son is also authorized for the Sradhya Karma. Therefore, the presence of son is needed, are required for the continuation of the life, and therefore Hindu view of life attach more importance to the son. Therefore, in the absence of biological son, a person is authorized to adopt a son. Friends, under the Sastric Hindu law, we also considered two different kind of son. One is the Dharmaj Putra and another is Kamaj Putra. Dharmaj Putra means a son, eldest son. Because when you procreate a elder son, the only object in your mind is to discharge the duty and dharma through the elder son. Therefore, under the joint Hindu family system, father have a right to provide additional share to the elder son. This is not discriminatory at all. Why? Because elder son, as per the Smriti, responsible to discharge all the worldly affairs related with the father. For example, attaching the need of the daughter of father, sisters of father, and comply the social obligation which was attached to the father. Therefore, additional share may be allotted to the father. Have a purpose as per the spirit of entire life and system. Friends, as we discussed that although Smriti talks about the different kind of son, but detail on Dattak provided by Dattak Mimamsa and Dattak Chandrika. And along with these two principal texts, customary law also prevail and add value in the entire practice of the adoption in India. Friends, now the next question is, what kind of fundamental changes introduced by Hindu Adoption and Maintenance Act in Shastric Hindu law? And entire amendment may classified in different category. First, under the Shastric law, only the adoption of son was legally recognized. But now the adoption of both son and daughter is permitted. Under the Shastric Hindu law, only married male were permitted to adopt. However, under Hindu Adoption and Maintenance Act, allow even unmarried man, bachelors, to adopt a child. Under Shastric law, the consent of wife was immaterial for the adoption. Now, under the Hindu Adoption and Maintenance Act, consent of wife is mandatory. Under the Shastric Hindu law, married women were not permitted to adopt. Only childless widow could do so. But under the Hindu Adoption and Maintenance Act, even a married woman can adopt. Even an unmarried woman can adopt a child. Now friends, furthermore, under the Shastric law, the adopted son was required to be the same caste as adoptive parents. Now there is no such restriction. Under the Shastric law, orphans or illegitimate children were not eligible for adoption. However, under the current law, an orphan can legally adopted. Under the Shastric law, Dattak home was required as a proof of adoption. Now actual giving and taking is mandatory. There is no need about the Dattak home. Under the Shastric Hindu law, doctrine of relation back was recognized, which is now abolished. There were 12 kind of son recognized under the classical Hindu law. It recognized two kind of adopted son, Dattak and the Kritrim. Dattak form prevailed all over the India, whereas the Kritrim form prevailed in the Mithila and adjoining districts. By this discussion, we are able to understand the difference between the Shastric Hindu law and modern Hindu law. Under the Shastric Hindu law, a married man can adopt because a married man bound to discharge certain worldly affairs. Therefore, he is bound to have a son. Therefore, he was permitted to adopt a child. Therefore, there was no need to obtain consent from the wife. But now law is substantially changed. An unmarried Hindu, unmarried woman may adopt a child. A married woman may also adopt a child with the consent of husband. This is the fundamental difference. Adoption of daughter was not permitted in Shastric Hindu law, but now there is equality and now son and daughter equally capable for adoption. A person is capable for adopting them. Friends, Dattak home is no more, because now we are thinking that Dattak is a secular act. These are some fundamental changes were made by the Hindu Adoption and Maintenance Act in the domain of law of adoption. Friends, now I want to focus on the adoption under the other law and religion. The personal law of Muslim, Christian, Parsi and Jew does not recognize complete adoption in their original form, as non-Muslim do not have an enabling law to adopt a child legally, whose discourage means a non-Hindu does not have any enabling law to adopt a child legally. Adopting a child can only possible through the guardianship and under the Guardian and Wards Act 1890. This, however, does not provide the child the same status as a child born biologically to a family. It provides them with the status of foster childs and foster parents. Means a person may work as a guardian of the child but cannot adopt the child under the Guardianship Act. Therefore, a person having authority over the child is known as guardian, not parent. Friends, now the Juvenile Justice Act is the only secular law that provides provision for adoption for all the person irrespective of their religion. Friends, in a case of adoption, we are also focused about the inter-country law on adoption. The Hague Convention on the Protection of Children and Cooperation in the Interest of Inter-Country Adoption Convention is an international agreement to safeguard inter-country adoption. The convention concluded on May 29, 1993. The convention established international standards of practices of inter-country adoption. India's inter-country adoption procedure was governed by regulation implemented in 2017 and now updated in 2022 by the Official Gazette of Government of India, and by this gazetted rule now the inter-country adoptions governed. Friends, a non-resident Indian or an overseas citizen of India interested to adopt a relative child may approach an authorized foreign adoption agency or a central authority in the country of residence for preparation of their home study report and for online registration in child adoption resource information and guidance system. So this is the inter-country adoption system, friends. Inter-country adoption system work on the principle of Hague Convention and 2022 guidelines issued by the government. And for this, CARA is designated authority, and CARA now administrating all the issues related with the adoption other than Hindu Adoption and Maintenance Act. Friends, now I want to put the summary of the Hindu Adoption and Maintenance Act 1956. The title of this act is Hindu Adoption and Maintenance Act. This is the act number 78 of 1956. The date of enforcement is 21st December 1956. The preamble is very clear. The act amend and codify law relating to adoption and maintenance among Hindus. And structure of this act is, this act includes 30 sections which categorize in the 4 chapters. Chapter 1 is primary chapter, which includes section 1 to 4. Second chapter is associated with the adoption, which includes section 5 to 17. On the other hand, the maintenance from 18 to 28 and repeals and saving is the fourth one, which includes section 29 and 30. 29 now abolished, only 30 is relevant for this purpose. Friends, now let us discuss some point about the Hindu Adoption and Maintenance Act. Hindu Adoption and Maintenance Act is the first enactment on the subject of adoption passed by legislature. The Hindu Adoption and Maintenance Act 1956 is primary statute governing the law of adoption strictly for Hindus and contains rules relating to a valid adoption. Unlike the Hindu Marriage Act 1955, Hindu Adoption Maintenance Act has no operation beyond the territory of India. Section 1 sorts title and extent, provided that this act may be called the Hindu Adoption and Maintenance Act 1956. It extends to whole of the India. This act applies to any person who is Hindu and also applies to a Hindu domiciled in the territory to which the act extends. There is no scope for the extraterritorial operation in this regard, friends. Currently, the adoption under Hindu law is governed by Hindu Adoption and Maintenance Act. Friends, this is the only provisions which governing the entire law of adoptions prevailing among the Hindus. And this act have no extraterritorial operation. Friends, now certain other important observation. The statement of the object and reason of this act says that under section 10 of Hindu Adoption Maintenance Act, only a Hindu child can be adopted. It is difficult to determine the religion of child who are abandoned by their parents or whose parents remain anonymous. That such children may also be adopted under this act. They have been included in the definition of Hindu, especially under the Hindu Adoption and Maintenance Act. Since it is submitted that, notwithstanding the statement of objectives and reason, the explanation cannot be limited to the subject of adoption only. Friends, now I want to focus on the applicability of the Hindu Adoption and Maintenance Act. Friends, for the purpose of the application of this act, you may categorize the entire application in two contexts, territorial context and subject-wise context. Territorial context is now clear. This act only applied in the territory of India. This act have no application beyond the territory of India. And second part is subject-wise application. As per section 2(3) of the Adoption Act, it is very clear that who is Hindu? Hindu as defined in section 2 of this act, and act will applied on Hindus. Means a person residing in India, if they are not Hindu, they will not govern by this act. But if they are Hindu, Hindu also includes Baudh, Jain and Sikh, they will govern and regulated by this act. Friends, very interesting point is, for the purpose of defining the term Hindu, an additional explanation is added, especially under the Hindu Adoption and Maintenance Act. Although term Hindu defined in all four prominent legislations regulating the personal affairs of Hindu, but additional explanation BB only added in the context of these. And as per the explanation BB, any child, legitimate or illegitimate, who have been abandoned both by his father and mother, or whose parentage is not known, or who in either case is brought up as Hindu, Buddhist, Jain and Sikh, friends. This explanation BB was added in section 2 by the amendment in the year 1962. And this phrase referred to a child regardless of the fact that whether their birth was legitimate or illegitimate, who has been abandoned by both of the parents whose parentage is not known. If such child is brought up as both Hindu, Buddhist, Jain and Sikh, they are considered to be Hindu, and therefore Hindu Adoption Maintenance Act will apply on such children, and they can be given or taken in adoption under this act. This is the point, friends. So for the purpose of application, we should focus on the explanation BB of section 2, which is added in the year 1962. By this explanation, it is now clear that child whose parentage is unknown or abandoned by the parent, if child is brought up as a Hindu, then child known as Hindu and will be given and taken by the Hindu's law. This is the unique, and therefore this act also includes a child whose parentage is not known, treating them as a Hindu, friends. Now friends, I want to focus on section 4, overriding effect of this act. Friends, we already discussed the overriding effect of the Hindu Marriage Act, overriding effect of this Succession Act. The section 4 is same. It is now very clear that any text, rule or interpretation of Hindu law or any other custom or uses as the part of that law in force immediately before the commencement of this act shall cease to have effect with respect to any matters for which the provision is made in this act. Any other law in force immediately before the commencement of this act shall cease to have effect in so far as it is inconsistent with any of the provisions contained in this act, save as otherwise expressly provided in this act. Therefore, if the act itself say that some other law, custom and rule will continue, then the specific exception is allowed. The phrase for which the provision is made implies that in such context this act shall apply. A case, Dhanraj versus Suraj Bai, AIR 1973, Rajasthan High Court, page number 7. A question arose that whether a stepmother can give a stepson in adoption, held that no provision of Hindu Adoption and Maintenance Act govern this, therefore old Hindu law will apply. However, the traditional Hindu law practices will apply in an area where the act is silent, and such practices shall not be inconsistent with the act. Friends, how we can conclude the entire discussion related with section 4? Section 4 is very clear and simple that Shastric Hindu law have no role after this act. Any other law which is inconsistent with Hindu adoption law shall cease to have effect. But simultaneously, friends, for which the provision is not made, you may apply Shastric Hindu law. The case is very clear. Stepson and stepmother not mentioned in this act, therefore in this context Shastric Hindu law will apply and case will be dissolved on the basis of Shastric Hindu law. Again friends, in the context, friends, saving clause is also important. Section 30 talks about the saving clause. Nothing contained in this act shall affect any adoption made before the commencement of this act, and the validity and the effect of any such adoption shall be determined as if this act had not been passed. So section 30 talks about the saving, means certain things can not be affected due to the Hindu Adoption and Maintenance Act. And in this regard, a very important case is Dani Raji versus Chandraprabha, AIR 1975, Supreme Court, page number 784. Respondent pleaded she adopted the appellant in accordance with the custom of Gond Dattak prevailing in her community in March 1956, and she cancelled the adoption of appellant in July 1958 as per the custom of the community. Hence, he was not her adopted son. The problem before the Supreme Court was whether an adoption which had taken place before the enforcement of Hindu Adoption and Maintenance Act could be cancelled after the act come into force. Friends, in this case, 3 judgments were given by Justice Unnatwalia, Bhagwati and Matthew, and they represented the different view in regard to the section 30 of the Hindu Adoption and Maintenance Act. Justice Unnatwalia held that this section contains 2 parts. The first part says that the provision of this act do not affect any adoption which took place before the act. The second part says that the validity and effects of pre-act adoption will be decided on the supposition that this act is not passed. The second part clarifies the first part. To affect any adoption precisely means to affect validity and effects of adoption. On the other aspect of adoption, its cancellation do not fall within the scope of section 13. Means cancellation only in the context of the validity and the effect of adoption, as justice identified, friends. That is the field of section 15. Cancellation is the field of section 13 because it deals with the cancellation of adoption. If no objection can be raised under section 15 to the cancellation of the adoption in the Goda Dattak form, it would be valid in this case, otherwise not. On this issue, His Lordship held that section 15 applies to only those adoptions which were validly made in conformity with the chapter 2 of the act after its commencement. It is only a prospective provisions, it does not govern the adoption which took place before the act was passed. This is the view of one judge. But after the enforcement of this act, adoption can neither take place in accordance with the Goda Dattak, nor can it be cancelled by that custom because the custom now is stand abolished by this act. Sri Bhagwati also laid down the different judgment, held that first part of section 30 is wider than the second part. The second part is limited to the validity and effects of adoption, but the first part is not limited to those matters only. It touches every aspect of adoption including its cancellation. The first part means no provisions of Hindu Adoption and Maintenance Act, which also include section 5, will touch or relate to or apply to an adoption which took place before the act. Hence, section 15 does not apply to the pre-act adoption as an adoption made in accordance with the custom could be cancelled before the commencement of the act. The adoption which took place under that custom before the act can be cancelled even after the act. As per the custom, Justice Matthew concluded that section 30 saves from the provision of this act only the validity and effect of an adoption which had been made before this act come into force. It does not save cancellation adoption because it does not relate to any of these two matters. The custom of cancellation of an adoption is abolished by section 4 subclass A and 5 of the act. Hence, even the Goda Dattak cannot be cancelled after the commencement of this act. By this, we can conclude the entire discussion. The strength of the judicial opinion in the case can be arranged in two ways. On the scope of section 30, the majority opinion is that section 30 makes provision for only the validity and effect of adoption. And second, on the problem of cancellation of adoption, the majority is in the view that if an adoption could be cancelled before the act, the adoption which took place before the act could be cancelled even after the act in accordance with the old law or as per the old custom. Friends, in this light we can think certain questions. Is the traditional Shastric Hindu law of adoption is still applicable today? Why did Shastric Hindu law place such a strong emphasis on the importance of having a son? What is the impact of section 30 on this act? By this discussion, friends, I want to conclude my entire discussion related with the adoption. Friends, Shastric Hindu law put greater importance to the son because of material importance and because of the duty and to be discharged by a son. This act substantially changed the Shastric Hindu law and laid down a new scheme of the adoption. Now adoption is governed under this act. But section 30 is very important. Adoption which took place before the act will only regulated by the old provision of law, but adoption after the act only governed by this act, friends. Very interesting point is, friends, suppose if there is no provision under this act, then law of adoption prevailing under the Shastric Hindu law may also be applied in this case. Friends, by this discussion, we concluded the discussion on the difference. We also understand the fundamental point of the explanation BB, where abandoned child also considered as Hindu and they can be given and taken under this act. Thank you, friends. Thank you.